Okay, we're going to look at some cases involving conflicts and ethical issues. Well, the first case is In re Oklahoma, and this is a 1990 case, and it dealt with the issue, one of the bankruptcy rules involving disclosure. So the problem here is that there were 5 secured creditors, all represented by the same law firm. The debtor requested that counsel comply with federal bankruptcy rule 2019, which requires an entity to submit a verified statement and giving details and disclosing that the entity is representing multiple creditors. The lawyer representing the creditors refused, and there was a motion for sanctions in violation of 2019. So the question is, does this apply to just representing individual creditors? Is this rule really only for committees and that kind of thing, or does it apply to anybody? Well, it says every entity or committee representing more than one creditor should file a disclosure, so pursuant to this section. So it seems to apply to individual representation as well. So the debtor's position, of course, is that it did, and the law firm's position was that, hey, this is really none of the court's business. Why do they want to get involved in administration? This is really about committees that are formed and disclosing that, or informal committees, not really about a lawyer that has individual clients that he's representing individually. Well, the court obviously took a close look at this situation and analyzed it and basically decided, hey, this law firm has a conflict. It's representing multiple secured creditors, and basically, if it wins and represents one of these secured creditors aggressively, then there's going to be another secure creditor that's going to become unsecured. And so, in other words, there's a real conflict here, and it's a zero-sum game. And so the court decided and ruled that 2019 is exactly meant to disclose this sort of information and sort of conflict. And it's the court's job to make sure everybody in the process is being treated fairly. And in this situation, the court ordered that the law firm can't represent multiple creditors when they're in conflict, when they're interest conflict. He's going to have to withdraw from one or more of those cases. What's interesting to me is how could this law firm represent creditors with diametrically opposed interests? I mean, he could get conflict waiver letters, but still, this is clearly a conflict. That's a little bit baffling to me. I think he should have voluntarily. This should have been handled. This should have been handled in-house. Not sure. Not privy to behind the scenes here. We just have an opinion, but didn't seem to me to be a wise practice. Here's another conflict case, and you have to wonder why this ever got in front of a judge. 1989 Indiana case. Well, in this case, the attorney represented a creditor that had both an unsecured claim against the debtor's estate and a secured claim. And the attorney was authorized to serve as counsel for the unsecured creditors committee, even though he was representing Dowerfline Insurance Service, which had both an unsecured and a secured claim. So is that appropriate or not appropriate? So the question here is, can an attorney represent a secured or partially secured member, and also partially unsecured creditor who's also a member of the creditors committee, and represent the creditors committee as a whole? This is the relevant code section on this kind of issue, which is important to know about. 1103, an attorney or accountant employed to represent a committee may not, while employed, represent any other entity having an adverse interest in connection with the case. You would think that's pretty common sense, but we've got to write it out. Well, the court decided, look, he's representing a secured creditor. To the extent that that creditor is secured, he's got diametrically opposed interests to the unsecured creditors. So I'm I'm laughing because it's absurd. He can't represent unsecured creditors because the more a creditor is secured, the more a creditor is secured, the less money there is for unsecured creditors. So how can he fight for a secured creditor? And of course, every creditor wants to be as secured as possible, and at the same time represent a committee of unsecured creditors. I mean, it would be nice if you could do that, but it doesn't make a lot of sense. And the judge issued an opinion, actual and irreconcilable conflict exists between the interests of unsecured and secured creditors, and so this attorney's got to make up his mind who he wants to represent. I think there are other ethical issues here, but we'll limit it to discussion of this opinion in 1103B, which spells out the conflict rules here. This is a 1996 hometown case, Southern District, New York. Well, it involves this reminds me of two boys at a dance asking out the same girl. Anyway, Otterberg, everyone wants to retain Otterberg as creditors committee counsel. So you have two entirely separate cases here, Bradley's and Caldor, both in Chapter 11 who filed separate Chapter 11 cases. And they both want to hire Otterberg, a very well-respected creditor rights law firm. The trustee objected, citing a potential conflict of interest. So can an attorney represent the unsecured creditor committees of debtors who are economic competitors? After all, these are going after the same market. They're mid to high-end department stores, and isn't that, how can you represent competitors like that? Well, the relevant authority is 1103. It's also the Code of Professional, we've already looked at 1103. Also the Code of Professional Responsibility. Canon 4 requires the lawyer to preserve the confidences and secrets of his client. If there is potential competition, is that going to be an issue? Canon 5 mandates that an attorney exercise independent professional judgment on behalf of the client. Can it be independent if he's representing two different department stores that compete? Canon 9 provides that the attorney should avoid even the appearance of impropriety, like Caesar's wife. Shouldn't even be a hint. Is there a hint here of impropriety if he's representing competitors? Well, the trustee didn't like the fact that these department stores are in the same market and they're both in bankruptcy. And even though they don't have claim, in other words, they're entirely separate bankruptcy cases. Caldor does not have any interest in Bradley's. Bradley's does not have any interest as a creditor or otherwise in Caldor. Completely separate bankruptcy cases. They just happen to be competitors, and the trustee is uncomfortable with that. Let them hire somebody else. Well, the committee says, well, we're going to have delay. We have to find somebody else. We like Otterberg. Let's just not make such a fuss and let us hire Otterberg. Also, there's two entirely separate committees. They're not creditors of each other. The committees don't compete with each other. There's nothing to do with each other. So the code of professional responsibility is totally irrelevant. Doesn't bar Otterberg from serving on two separate committees and two entirely separate bankruptcy cases. Well, the court agreed with the committee, and his ruling went into a lot of detail. Adverse interests under 1103B. And first, he noted that neither the debtors nor the committees hold or assert claims against each other. There's no issue that they're involved in any way in the bankruptcy cases. Although they're economic competitors, that is not an adverse interest pursuant under 1103. Interests are not merely adverse because it's possible to conceive hypothetically of some kind of situation, a merger or possible buyout, some kind of future situation that doesn't exist now. There might be a conflict. So it's not, the judge is saying 1103 is not meant to prevent employment of an attorney in this kind of situation. And also, Otterberg is putting up a so-called Chinese wall, going to have two separate teams. So that even makes it less likely that there's a conflict here. The court also looked at the Code of Professional Responsibility. Canon 4 is not violated. There is no current or proposed litigation between the two debtors or the committees. There's no claims between. They're totally unrelated. No conflict. Canon 5 is not violated because the kind of role that the counsel for the creditors committee is supposed to perform, it's not going to have any conflict. The creditors committee for Caldor and the role that the attorney is going to perform there, it's not going to have any conflict with Bradley's and vice versa. And being economic competitors does not result in a violation of Canon 5, and it's not a direct conflict. It's maybe a potential conflict, but it's not an actual conflict. Canon 9 is not violated just because the debtors are economic competitors. The committees themselves are not competitors anywhere. They're just committees of unsecured creditors. They're not competing with each other in any possible way. So the court ruled in favor of the creditors committee and permitted retention of Otterberg. It seems to me a little bit of a stretch here by the trustee. Whatever, he felt otherwise. But the takeaway here is it's not a hypothetical conflict that's being prohibited. It's an actual conflict. This is a fairly recent conflict case, 2010 bankruptcy court level in California. Okay, so in this case, Nyami was an attorney, I guess she still is, who consulted with the debtor, Muscle Improvement, on preference cases. She looked at documents. She reviewed the financial condition of the debtor. This was prior to the bankruptcy file. Apparently, they were considering retaining her, and for whatever reason, they didn't. And then she ends up representing the major creditor in the case, Allstate. And the debtor is suing Allstate, started an adversary proceeding against Allstate. And so it's not just some kind of passive creditor representation. It's representing Allstate in the context of an adversary proceeding between this creditor and the debtor in the context of a situation where Miami had consulted previously prior to the bankruptcy being filed with the debtor Muscle Improvement. So Muscle Improvement moves to disqualify Miami. Say, hey, we disclosed things to her. How can she now represent an adversary? It's just not right. Of course, Miami says, no, I think it's okay. So there are three issues here. Whether an attorney can be disqualified simply because the attorney met with a potential client and ended up not representing that client, in this case the debtor, and ended up representing another client. Whether the subject matter of the attorney's meetings with the potential client were substantially related to the subject matter with the new client, between the former potential client and the actual later client, was the subject matter substantially related. This is an issue that comes up in the case, pursuant to the applicable law, and whether the attorney's relationship with the former potential client was one in which confidential information would ordinarily be disclosed. Well, it's California, so the court applied Local Rule 2090 2A, which governs professional responsibility, and applies the California rules of professional conduct. Every state has rules of professional conduct that may differ slightly from the model rules of professional conduct. But in most states, the rules are pretty similar. Rule 3-310, the California Rules of Professional Conduct. A member shall not, without the informed consent of the client or former client, here wasn't a client or a former client, accept employment adverse to the client or former client, where by reason of representation of the client or former client, the member has obtained confidential information material to the employment. Well, here, it's not a client. It was a potential client. So Miami is trying to distinguish that rule, and we'll see if she succeeds. The substantial relationship test also applies, and that governs attorney disqualification motions. To prevail, the former client, in this case, was not a client, must satisfy two elements. The subject matter of the attorney's current representation is substantially related, whatever that means, to the subject matter of the attorney's earlier representation, whatever that means. Is a consultation a representation? Is that a client or is not a client? The attorney's earlier representation of the former client was one in which confidential information would ordinarily be disclosed. So whatever confidential information means, whatever ordinarily means, is going to be decided on a case-by-case basis or based on precedent. Anyway, so those are the issues, and to me it's basically common sense. Is the current representation substantially related to the subject matter? There's a smell test. Whether you're going to represent a new client on the same issue after you've consulted with a former potential client, or you had a client on that same issue, doesn't seem right. Doesn't seem fair. I think that would put the former client at a disadvantage. It's just common sense. People know what's wrong. They don't need law, but law exists because they do it anyway. Okay, debtor says since confidential information was exchanged in the consultation, Naomi should be disqualified. Smell test. It smells bad. And not only that, confidential information was exchanged. The creditor argues that, well, the only financial information Naomi received is information is now public. So it's not confidential anymore. And they're referring to financial information that had to be disclosed in schedules when the company filed for bankruptcy. So now it's available to everyone. Why should that be an issue? Also, the creditor argued at the second meeting, there was a third party at the meeting, and this prevented the communication between the debtor and Naomi from being confidential. I apologize to Naomi if I'm mispronouncing her name and she's listening to this. I'm doing the best I can. Well, not surprisingly, at least to me, the court found that there was a conflict here, and that's the purpose of Rule 3-310. And why is there a problem? Because she met with the debtor, and it doesn't matter if the debtor didn't retain her or did retain her. In this case, didn't retain her. It's irrelevant. She met with the debtor. She met on the same subject matter, which she's representing the new client, new creditor. So doesn't pass the smell test. It's just not right. Also, confidential information would ordinarily be disclosed. Doesn't matter if it was later disclosed. That's not the rule. It would ordinarily be disclosed in that kind of consultation. The financial consultant did not destroy confidentiality, and the judge says, "Hey, you could have gotten written consent. That's what you were supposed to do. That's what you should have tried to do, and you didn't do it." And here you need to be disqualified on conflict of interest grounds. I think it's pretty obvious, but I wasn't there. This is a bankruptcy level case, Ohio, 2006. This case deals with getting court approval to retain an attorney to challenge the alleged secured status of a creditor's claim against the estate. So it's a little bit different from the other cases. Here, the court has to make a decision on whether a conflict exists, but the attorney is representing the estate. The attorney is not representing a private party or a particular creditor. The attorney is going to be representing the estate. So different rules apply and the bankruptcy code applies. So here, anyway, the debtor is seeking to hire an attorney on contingency, essentially to challenge a creditor's secured claim. And this attorney already represents two unsecured creditors. So now the trustee is saying, well, I want this attorney to represent us with respect to challenging a secured creditor's claim. So is this a conflict? Is this impermissible? That's the question. The applicable code section here is 327, which governs hiring people, gives the judge discretion to approve or deny hiring certain people to represent the bankruptcy estate. 327A, except as otherwise provided in the section, the trustee, with the court's approval, may employ one or more attorneys, accountants, appraisers, etc., as long as they do not hold or represent an interest adverse to the estate, whatever that means, and are disinterested persons, whatever that means. And both those terms, one of the terms is defined in the definitional section in 101. The term disinterested person is defined as a person who does not have any interest materially adverse to the interests of the estate or of any class of creditors, etc. So not conflicted. And the Roberts test, which is case law, defines hold an interest adverse to the estate if two or more entities possess an economic interest that would tend to lessen the value of the bankruptcy estate, or that would create either an actual or potential dispute in which the estate is a rival claimant, or two, possess a predisposition under circumstances that renders such a bias against the estate. So again, they're conflicted. Well, the trustee argued there's no conflict because the attorney is being used for a special interest, and trying to reduce a creditor's secured claim is going to benefit all unsecured creditors. Why? Because that allegedly secured creditor is going to be unsecured. It's going to get paid a much smaller portion of the assets in the estate. If the creditor is secure, it's going to get paid in full. If it's unsecured, it's going to get paid like everybody else. So less money is going to be paid to that one creditor. Not surprisingly, that one creditor is objecting to retention of this attorney on contingency. And if this attorney is found to be not disinterested and rejected by the court, trustee did not have the funds to hire anybody else. This attorney agreed to represent the trustee on contingency. So if the trustee doesn't win on this little battle here, then this creditor, it will be unable to challenge. The trustee will be unable to challenge this creditor. So of course, this creditor has certainly motivated to object to this attorney being retained. Why? Because this attorney is going to fight this creditor. So the GMAC is saying the attorney is not a disinterested person, and the reason it gives really don't make a lot of sense. I mean, the creditor seems to be implying, well, the creditors are representing other unsecured creditors, and if the attorney wins here, then we, GMAC, are going to have a greater unsecured claim, and so we're going to be essentially competing with unsecured creditors that the attorney currently represents, which doesn't make a lot of sense because there's going to be more money in the estate for everybody, and there'll probably be more money in the pot available for unsecured creditors. So this creditor will have a bigger claim, but instead of having a secured claim and tying up that money will go into the pot for unsecured creditors. Well, the court basically said, if you look at 327C, I'm allowed to permit retention of an attorney, even though that attorney represents a creditor, if there's no actual conflict, and if the attorney does not hold an interest adverse to the estate. And here, there is no interest adverse to the estate, and there's no actual conflict. So I'm going to allow the trustee to retain this person. As far as hold an adverse interest, the court applied the Roberts test and found that for this special purpose, just to object to this assertion of a secured claim, there's no adverse interest held by this attorney. And in fact, it's the opposite, because he's actually helping the estate, helping collect assets for the estate. And if this attorney were not available, then the trustee would not be able to essentially collect assets for the estate because the trustee is objecting to a secured claim, and if that claim becomes unsecured, then there's more assets available for all creditors. So the court stressed that it's acting under 327C, and that for this special purpose, um, there's no conflict and there's no adverse interest, just merely because the attorney represented other unsecured creditors. All interests are aligned, no conflict. This is a Northern District, New York case, 2008. The case basically illustrates that if you're applying to the court to be retained in any capacity in a bankruptcy case, you have to be scrupulous about disclosing any potential conflicts of interest, or what's going to happen? You're not going to get paid. In this case, the trustee filed an objection and seeking disallowance on a payment application of a law firm seeking to be paid for its work representing the unsecured creditors committee. Trustee also saw disgorgement, which means clawback, which means he wants the money back that was already paid to this law firm. And the reason is that the attorney who was primarily responsible for the case, for representing the creditors committee, vaguely disclosed that an attorney, and this is a quote, an attorney is related to an officer and shareholder of one of the general unsecured creditors of the debtors. And he wasn't very specific that he was the son-in-law of the CEO and president of one of the major creditors in this case. Also, his wife at some point became in-house counsel at that company, and this was not disclosed. And the question is, so what? Is this really such a problem? He did disclose in general terms that there was at least his status, that he was related, but it wasn't very specific. So is that an issue? This is pursuant to Federal Rule of Bankruptcy 2014. 2014 in part says the application shall be accompanied by a verified statement of the person to be employed, setting forth the person's connections, etc. So was this a sufficient? It seemed to be a compliance with 2014. Well, the trustee's argument is that it wasn't really specific enough, and because of that, no one noticed or no one paid attention. And if it was specific, which creditor, exactly how he was related, the fact that his wife at some point became corporate counsel to this creditor, if it was fully disclosed in all that detail, then the court might not have approved the retention of this particular law firm. The law firm's position is that first of all, it was disclosed, and 1103 does not disqualify a law firm just because the attorney in the firm is related by marriage to one of the committee members. So there's no specific section disqualifying him, and also his wife only started working after some period of time. She wasn't working as in-house counsel when he was retained, so that did need to be disclosed. And some other factors. Well, the judge basically said, hey, I've been sandbagged, and so is everybody else. You weren't, the judge implied that maybe you were purposely vague. In other words, maybe there was bad intent here uh, to to try to slip this under without notice. And the judge is basically saying this was not enough disclosure. Later in the case, this relationship caused issues, caused tension or conflict between the committee and the debtors. If I had known about this, I may not have approved it. And I'm angry enough that the appropriate remedy is fee disallowance. You're not going to get paid. Either it was careless or it was intentional. Whatever it was, don't mess with the court. Problem with conflicts of interest is that even if they don't really have an effect on the client, they just have a bad smell, and they make lawyers, the entire legal profession, look bad. In this case, we're looking at the issue of business dealings with the client and uh, when not to do it. So in this case, obviously, this is an example of a business deal that should not have been done with a client. And this is a Nebraska case involving the purchase of farmland, and this is an action brought by the Nebraska State Bar Association against Mr. Thor, an attorney. So what happened here is these farmers were in trouble. Um, they're considering bankruptcy. They own farmland, and the problem is that, or the issue is that the farmland apparently is all leaned up, so they don't have any apparently, and this is not an issue that was really decided, but it would appear that they didn't have any equity in the property. Um, their attorney who was handling their bankruptcy case offered to buy the property. Essentially, since they had no equity, essentially the attorney was going to be buying from the lender. The problem is that he didn't disclose the potential for conflict. He didn't disclose that he was getting higher offers. That's apparently someone, and this is not in the slide, but in the opinion, someone a potential purchaser testified that he actually offered more, and this was not related to the client's seller. And so also the entire transaction was not disclosed. He went to some lengths to make sure apparently that it wasn't published in the newspaper, and he purchased through a straw man. So Mr. Thor also, he didn't disclose, well, he did disclose to the client that the listing agent was going to be Thor Realty, owned by his father, and he did disclose that they were going to be charged a 5% commission, but he did not disclose that he was the actual purchaser. So the question is, there are really multiple questions. Whether an attorney is representing a debtor in a bankruptcy can purchase the debtor's property subject to the bankruptcy litigation. It was part of the bankruptcy. But more than that, the whole fact scenario here, should an attorney conceal, uh, not relate to the seller that there are other buyers, and not fully disclose the nature of the conflict. And what is the nature of the conflict? The nature of the conflict is maybe they could have gotten a higher price. Maybe they could have, maybe, who knows, although the opinion seemed to doubt it, but it's possible that there would have been money left over to pay creditors after paying the secured creditor. Who knows? Anyway, the relevant authority, Code of Professional Responsibility, applicable in Nebraska, Canon 5, limiting business relations with client. Lawyers shall not enter into a business transaction with a client if they have differing interests therein and the client expects the lawyer to exercise his professional judgment therein for the protection of the client, unless the client has consented after full disclosure. It's just common sense. If you're going to do business with a client and there's a potential for a conflict of interest or an actual conflict of interest, um, you got to disclose it. Otherwise, it's a secret. You're not telling the client that there's a problem here. Okay, Bar Association is not happy, and Thor should be sanctioned because he took actions that were inconsistent with the best interests of the client and deliberately concealed these actions from the court, the creditors, interested parties, meaning other potential purchasers, and the client. Didn't fully disclose it. So I think it's number two that had an awful smell. Whether his actions were inconsistent with the best interest of the client, not really that clear in this case, but these are the allegations. So Thor says, well, they wouldn't have got anything anyway. They didn't have any equity in the property. So how am I acting in contrary to their best interests? He claims he told them to seek advice from another attorney. The opinion did not gave that short shrift, and heard testimony from others saying he was concealing other bids. And not surprisingly, court found against Mr. Thor. Canon 5, DR 5103. It's in the middle of a bankruptcy case. Buying the property is pretty egregious. Not going to tell the judge, not going to tell creditors, not going to tell anybody. I don't think he had a shot on this one. DR 5104. Well, apparently he did tell the debtors or the debtor that he was actually the person buying the property, but he was concealing it from others. And he didn't fully disclose or explain what the problem with that was. Didn't explain it in detail. Maybe somebody else would have paid more. In fact, he was apparently, according to the opinion, he was allegedly hiding other bids from the debtors. So 104, I don't think he had much of a shot on either. 102, Thor is guilty of misconduct. He used his position as attorney. So they threw the book at him. The thing is, it was just so unnecessary, in my opinion, because really, and I have to think that Thor was probably thinking, hey, I'm not harming them. They have no equity in the property. And looking at the opinion, you kind of have to agree. But you also have to agree that there's a smell. You should have disclosed it. He had nothing to lose, really. He probably could have bought the property anyway. Maybe paid a little bit more, maybe not. But the fact that he tried to do it in secret and do non-competitive bid, a non-competitive sale in the middle of a bankruptcy case, it just shouldn't have been done. Obviously, an ethical issue. Well, he's suspended for a year, which it's not disbarred. He's suspended for a year. I think the court recognized that, probably, although no one's ever going to know for sure, probably the client was not harmed. But it's not the way to act as a lawyer, and there's got to be some punishment. I'm sure a year of his closing his law practice for years is going to be a lot more expensive for Mr. Thor than paying a little more if he had disclosed everything, paying a little more for this farmland. This is a 2002 case, an example of an attorney maybe not doing the right thing. Well, what happened here is a bankruptcy attorney wanted to make sure he always got paid. So he had the clients enter into a so-called lien statement when they retained him, and he actually became a secured creditor. And if they didn't pay, he'd put a lien on their homes. Also, he had them write in the lien statement. He would have the client agree that he was exempted from the homestead exemptions. So basically, the U.S. trustee found out about this and brought it to the court's attention and filed a motion for sanctions. What's important also is that this was not disclosed to the court. The special fee arrangement was not disclosed to the court or anybody except maybe the client. And the lien, if there was a lien, if the lien statement was recorded or there was a potential lien or any aspect of this arrangement, sometimes my understanding is that the lien statement was recorded actually during the bankruptcy case, and this was not disclosed to the court or the U.S. trustee's office. And the debtor schedules, the debtor's information that is filed with the court called schedules, these were not amended. So no one knew about this, basically. This was sort of a secret arrangement. After the bankruptcy case, the attorney would sometimes exercise the lien and actually purchase the debtor's home and then resell it for a profit. I would say this is a little bit egregious. So there's a lot that's ethically wrong with this. That's one of the issues, but I'll go into the other ones in a second. Well, first of all, you've got to disclose to the court your compensation, what you're going to be compensated, and your compensation arrangement. That's black letter basic bankruptcy law. So that wasn't done. That's pursuant to 329 in 2016. And then, according to the rules of professional conduct, if you're going to enter into, essentially this was a business transaction ending up in a transfer of property by the client. And there's a question whether this was fair and reasonable, whether it was fully disclosed in writing, and certainly the client was not informed that use of independent counsel might be advisable. I'm sure they would have advised against signing a lien statement like this. So should this lawyer be sanctioned because he entered into secret agreements that created conflicts of interest, that violated the bankruptcy code, the federal rules of bankruptcy procedure, and the rules of professional responsibility? Or, as the lawyer said, there's a misunderstanding here. I didn't know what was going on. Well, oversight, what's the big deal? That seems to be his explanation. Well, the court basically threw the book at this lawyer. In the opinion, the court actually expressed admiration for this particular lawyer. It said he's very articulate, very capable, very, very professional, and an excellent lawyer, which actually worked against him because the court didn't believe for a second that he didn't know what he was doing and that he didn't know the law and the rules. So he just chose to ignore them. Also, that this was a conflict of interest with his client. That he didn't advise his client to seek independent counsel, and so on and so on. There's another situation of a lawyer acting badly. Lawyers Gone Wild, 2004, Wisconsin. Well, this was brought by the Office of Lawyer Regulation. Never heard of that before. I guess that's what it's called in Wisconsin. When a lawyer gets into trouble, that's who they hear from. Anyway, so this attorney was lending money. The lesson here is you can't be a vulture investor and a bankruptcy lawyer at the same time with the same person. So he's lending money to people who are in deep financial trouble, and of course, he's also getting interests in real estate, their businesses, their personal property, getting security interests. not disclosing this while he's representing them in a bankruptcy proceeding. Not disclosing this. It's laughable. Not disclosing this to anybody, of course. The opinion didn't say what kind of interest rate he was getting, but I can imagine. And not disclosing to the client that this is a conflict of interest, that he's now a creditor of the client, in addition to representing them in a bankruptcy case where he's supposedly advising on how to discharge debt. Anyway, well, can you do that? I think you can guess what the answer is. The Wisconsin Supreme Court rules basically follow the model rules of professional responsibility that I believe every state has. And, it's the same verbiage. It has to be fair, has to be fully disclosed. The client has to be told that he should seek the advice of independent counsel. And there's a consent in writing. So none of that took place here. Also, you can't enter into a situation where you're doing business with the client and it creates a conflict. All right, so the lawyer argued, look, they signed loan agreements. What's the problem? That's written. It's, it's just no need. It's laughable. There's no need for a written waiver. They signed They signed the agreements. So you can guess what the court is going to say about that. Well, the court said pretty much that's absurd, and that would basically render, I'm sorry, but it's funny, it's ridiculous, render the entire rule superfluous. Uh, you have to have a separate conflict waiver agreement. I can't believe this argument was made was made with a straight face. But anyway, it didn't win, and obviously you have to have a written agreement. You have to have written notice. You have to give the client, again, just repeating myself, opportunity to consult with an independent counsel. So the conflict of interest claim regarding claims trading, 1988 case, appellate level, Chicago. Well, this is an appeal, and the attorney lost at the lower level, obviously. And the question is, Rosenstein was a bankruptcy attorney who was representing the debtor, and he was also president and apparently sole owner of a company called Stickney. Stickney was buying unsecured trade claims against that same debtor. So while he was representing Milwaukee Road, which is the debtor, he was also representing and advising Stickney, basically representing and advising himself on the purchase of trade claims. So can you do this? I mean, that would be nice if you could represent the company as a bankruptcy attorney and also trade claims. I think you definitely increase your earnings as a bankruptcy attorney. Unfortunately, Bankruptcy Rule 8-212C, denial of allowance, no compensation or reimbursement shall be allowed to any committee, attorney, etc., who, without approval of the court, purchased or sold claims against or stock of the debtor. So it's pretty black and white that you can't do that. Although this attorney did have a couple of arguments. Well, he's saying he's not Stickney. He owns Stickney, but he's not Stickney. So it wasn't for his own benefit, didn't have a conflict of interest. His other argument is, hey, I didn't get any benefit from being the attorney for the debtor. Anybody could have researched this, and it's all part of the public record. So why should I be denied the ability to trade claims, or Stickney should be uh, um, prohibited from trading. Well, not prohibited from trading claims, but why should I be denied getting paid attorney's fees by the debtor just because Stickney, a company I had an interest, traded claims and the information is available in the public record? Well, the court didn't buy the argument that he had different interests from Stickney because he's 100% owner of Stickney. So I think that was a tough argument to make. The argument that he didn't have access to non-public information, I actually thought that was a good argument. Um, but basically, the court said, look, he's gonna have just by being the bankruptcy counsel and being in the information flow, he's going to have special knowledge. And whether it was public or non-public, I mean, who can really tell? He's representing the debtor. I think it's difficult to make that determination whether he had access to non-public information that he used. And the court said it doesn't matter. We've got a rule here, 8212C2. That's why we have this rule, so we don't have these kind of issues. So fee application denied, or at least the bankruptcy court decision, the district court decision denying fees is affirmed. Yeah, so I just said that. But intimate knowledge of the proceedings gives him an edge, and that's the kind of edge that this rule is designed to discourage. There's a smell here. You can't have the attorney for the debtor also profiting by buying trade claims. It's a smell, whether it's a problem or not. You have to be like Caesar's wife, and this was nothing like Caesar's wife. This is another lawyer conflict case, 2014, fairly recent, Oregon. Well, again, a situation where the lawyer is entering or allegedly entering into a business transaction. Is it or is it not? The client owned real estate. The lawyer advised selling the real estate to take advantage of an exemption and to buy a new home. The lawyer proposes to act as the client's real estate broker and earn a commission when the client finds new property. Apparently, the client found new property, and the lawyer, for some reason, told her not to get a professional inspection done on the new property, and she had problems with the new property, so she fired him and complained. And the issue is, was this a violation of the rules of professional conduct? So is being a real estate broker just earning a commission? Is that entering into a business transaction? Is that significant enough to knowingly having acquired a pecuniary interest adverse to the client? There's model rules of professional responsibility in Oregon. Pretty much the same verbiage. Well, the lawyer was arguing it's not really a business transaction, it's just an agreement to serve as a real estate broker. It's just providing another service besides being a lawyer. The prospect of receiving a commission if the real estate closed did not create a conflict of interest with his legal duties. And they're completely different. Representing her in a bankruptcy and earning a commission are completely different things. So there's no completely different services, not related. So how could there be a conflict? The bar argued that the lawyer had a personal financial interest in obtaining a new house for the client, and this limited his ability to be objective in representing her, and that will always create a conflict of interest in a situation like this. Either you're a lawyer or you're a real estate broker. You can't be both, because as a lawyer, you have to be completely objective. And if there's a sales commission being dangled out in front of you, maybe you're going to lose your objectivity. Well, the court found that this was a business transaction. He didn't advise her to seek independent legal advice. He didn't follow the rules. And there is a possibility of potential and actual injury since the lawyer is conflicted. However, the lawyer didn't violate Rule 1.7a. There's no evidence that problems that followed her purchase of the home stemmed from the lawyer's interest in getting a sales commission. Well, they suspended the lawyer for 30 days. It's more of a rap on the knuckles. And you could see why. I don't see a huge ethical lapse here. It's more of a warning. Don't put yourself in that position. If you do, follow the rule. Get it in writing. Follow the rules also as far as recommending independent counsel, and get that signed off in writing. My Between the lines, my feeling here is that the rules weren't followed. That's why they're there. You got to follow them. Connecticut 1998 1998 case. Well, in this situation, question is whether the law firm could represent an unsecured creditor in a situation where the law firm itself is owed money, so it's a creditor, and the law firm had represented the debtor, but no longer represented the debtor. The creditor had fully consented, the rules were followed, and this is an objection by the debtor to the employment of this law firm by an unsecured creditor. Well, that's the issue. Okay, applicable rules. Rule 33, you shouldn't take the case if you're going to be a witness as a lawyer or you expect to be a witness. 1.7, you shouldn't take the case if you're conflicted unless the client agrees and you reasonably believe the conflict will not affect your client. 1.9, you shouldn't take the case if the case is a substantially related matter with respect to a former representation and the former client does not consent and the former client's interests are materially adverse to the second client's interests and the information was confidential or the information the exception is if the information has now become generally known. So, in other words, if the information was not confidential, then you can take the representation, or if the information has now become generally known. So the position of the debtor is that Rogers and Wells might be called as a witness in an adversary proceeding regarding an unsecured claim. They're conflicted because they have a status as an unsecured creditor. And so the conflict is they're representing another unsecured creditor. And there's a natural conflict between two unsecured creditors because if one loses, the other creditor will be paid more from the same pot, essentially. Also, there was prior representation of the debtors by Rogers and Wells in an attempt to secure a loan, and that compels disqualification because the interests are adverse between the former client, the debtor, and the current client, an unsecured creditor. The defendant, the law firm, argued, well, we're not likely to be called as a witness in this matter. It's very slight. the conflict is not going to, there may be a conflict, but it's not going to affect my representation or our representation of an unsecured creditor, and the unsecured creditor consented. And as far as the prior representation of the debtor, we were representing the debtor in obtaining an unsecured loan. We are now representing the sole shareholder of that debtor, the parent company of that debtor, and so there was no legitimate expectation of confidentiality. Essentially, we're representing the sole owner currently, and we were representing essentially the same entity when we were representing the debtor. Well, the court agreed with respect to 33, unlikely to be called as a witness. That chance is slight, so a law firm should not be dismissed on that basis. As far as 1.7b, yes, there's a technical conflict because the law firm's also an unsecured creditor, but we're not convinced that the law firm should not represent another unsecured creditor, or that their representation will be affected by the technical conflict. But 1.9 has been violated. There was a substantial relationship between the prior representation of the debtor and the current representation of the unsecured creditor. So the law firm cannot continue in the case. Okay, this is another example how doing business with a client in the context of a bankruptcy case can turn into a disaster. It's a Nebraska 1995 case. So in this situation, there was an individual, James Sauer, and his company, JAS Enterprises, both filed for bankruptcy, Chapter 11. And a secured creditor household foreclosed on Sauer's home is individually owned home. In other words, not a home owned by JAS Enterprises, the corporate entity. And Sauer's bankruptcy attorney, Pruss, decided to purchase the home. We're going to do him a favor, hold on to it for him, and he can pay as long as he pays the monthly mortgage payments. So entered into this agreement with James Sauer. And so the question is, can she still act as attorney for these estates after she's entered into an agreement like this? Also, the Stocks, who had claims against the corporate entity, objected to this arrangement, and basically they're alleging that part of the money that Pruss used to purchase the property from the lender came from the JAS Enterprises estate. So you have a situation where money is coming out of the corporate entity to apparently help purchase the home of the former owner of, or one of the owners of JAS Enterprises, James Sauer. So did the attorney violate ethical rules, conflict of interest rules being among them? So there are a lot of different rules here, ethical rules. 327, whether she can be employed by the bankruptcy estate, whether she can continue to represent the estates, that's an issue. Whether she's a disinterested person now that she is a creditor of at least one of the estates, James Sauer, since he is obliged to her to make mortgage payments. and whether other ethical rules were violated, including conflict of interest rules. Well, Proust makes the argument, look, it wasn't property of the estate. This was property that was foreclosed on already, property belonging to a lender. I bought it from the lender. I didn't buy it from the debtor. It didn't belong to the debtor anymore. I bought it from the lender. So it's an arm's length agreement with a third party. As far as the money that allegedly came from one of the bankruptcy estates, not a problem with that. I'll just accept that as legal fees, and we'll work it out that way. Um, the stock's argument was she can't represent the estates anymore because she's conflicted. She's now a creditor of at least one of the estates. She's not disinterested, and the transaction uh, uh, inherently had a conflict of interest between attorney and client because the client had an interest in the property and is currently represented by the attorney. And full disclosure should have been made to the bankruptcy court. And there was improper use of bankruptcy estate funds without court approval. Kind of a mess. Well, not surprisingly, the court found that the attorney did violate Nebraska Code of Professional Responsibility, and it basically found that there's an appearance of, at the very least, there's an appearance of impropriety. Our client did own the property, and perhaps still holds an interest, and it just doesn't pass the smell test. There was lack of disclosure to the bankruptcy court. She did take an interest in property that was subject to litigation, and certainly she's representing the estates, and this issue could raise litigation issues in the estate with respect to use of funds belonging to one of the estates to finance her purchase of the house, and so she should not represent the estates, and she also put herself in a situation where there's a conflict, certainly a potential conflict of interest between the estate's interests and her interests. And she shouldn't represent Sauer in his individual capacity because they now have a debtor-creditor relationship, and that's an inherent conflict of interest. Not surprisingly, the court also threw out the argument that she could elect to pay herself that money as attorney's fees if it did come from the bankruptcy estate. And the reason is that the bankruptcy court has to make decisions and approve attorney's fees. She can't make that decision. That's the bankruptcy court's decision. So I think the lesson here is you got to be like Caesar's wife and not get involved with a business dealing with a debtor that you currently represent, because it ends up being too tangled up. Let's see, bankruptcy appellate panel, Ninth Circuit case, 2005. Okay, so state of Hawaii made a loan to the debtor, filed a collection action. The debtor consults with a law firm, WCE. To be retained, WCE requires a blanket security interest in favor of the law firm of all the debtor's assets. Involuntary petition is filed. WCE files a secured claim against the debtor, and the trustee objects, saying this ain't right, essentially. So is this permissible? You can understand why a bankruptcy law firm would want to secure payment from a debtor that's in financial trouble. But is this permitted? Can you ask the client as part of your retention agreement to give you a secured interest in all their assets? Well, this is the applicable law. Hawaii rules of professional conduct 1.8a. A lawyer shall not enter into business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client, unless, etc. Here, the client did not. Well, maybe the client agreed in writing. But was the client given a reasonable opportunity to seek the advice of independent counsel? Well, the law firm argued, hey, they could have hired independent counsel. We weren't stopping them. They had opportunity. And also, we have a right to put a lien on pursuant to the rules. It says so in the statute to protect our attorney's fees. The trustee is saying, no, getting a security interest, uh, not by law, but by agreement, violates the Hawaii rules of professional conduct. Also, the client did not have a reasonable opportunity uh, to enter into a security interest in which the lawyer, I'm sorry, to enter into a retention agreement in which the lawyer acquired a security interest adverse to the client. Well, the court found, that the security documents were drafted on the same day they were presented, and this didn't give the debtor a reasonable opportunity to get counsel. Also, the lien that WC is referring to is one granted by law, a charging lien, for example, on a recovery obtained by the client. It doesn't apply in a situation like this, where the attorney is entering into a security interest agreement with a client adverse to the client. This is a district court case, Michigan, 2010. It's an appeal from a bankruptcy court decision. And this involves some apparently very unhappy creditors who sought removal of a trustee. And the grounds for removal is that, according to these creditors, he messed up a lot of litigation. He should have sued insiders. He should have filed a preference case. He didn't. It's too late. Um, and other matters. They had a laundry list of complaints against this trustee, and basically their argument is he's conflicted because he's not going to investigate himself for wrongdoing. So for that reason alone, he's conflicted and should be removed. The creditors gave pretty specific facts. They didn't just, allege general wrongdoing. They gave specific facts that the bankruptcy court was aware of. And the trustee basically said, hey, this is all, first of all, a number of these claims are barred by a statute of limitations, so there's no point in investigating them against myself. And as far as the rest, it's just allegations. You can't, if creditors could get rid of trustees just based on allegations, the bankruptcy system would be chaos. So this is the applicable section 324. Very rare to have a trustee removed, by the way. Well, the district court affirmed the bankruptcy court. The bankruptcy court decision was yes, removed him, and the trustee appealed, and the district court said it was a fairly lengthy opinion, and the district court's conclusion was that there were enough specific facts here that an investigation was warranted, and the trustee would be conflicted in performing such an investigation, obviously. However, this is a special situation because the facts were very specifically shown, and the bankruptcy court was aware of those facts. For instance, the bankruptcy court had dismissed an adversary proceeding brought by the trustee due to discovery violations. So the bankruptcy court was fully familiar with many of these facts, and that made this situation unusual because the creditors were not just bringing general allegations; they were alleging allegations, but supported by specific facts. If they just brought general allegations, it wouldn't have been enough to create a conflict of interest. But this was enough, and so it's a case by case basis on whether there's enough evidence presented to bring a move-in's position beyond mere allegation and result in the successful removal of a trustee. Here, the interest that was adverse to the estate is potential recovery against the trustee himself for malpractice. Too much of a conflict.